Oxbryta lawsuit. This video covers key facts about Oxbryta, voxelotor, what the drug was intended to do, what complications emerged, why lawsuits are being filed, who may qualify, and how TorHoerman Law can help. Oxbryta was intended to help patients with sickle cell disease, but for many, the outcome was markedly different. If you believe you've experienced serious harm after taking Oxbryta, you don't have to pursue justice alone. Reach out to TorHoerman Law today for your free consultation and let us help examine your case. What is Oxbryta? Oxbryta was approved in 2019 to treat people 12 and older with sickle cell disease, SCD. Oxbryta works by hemoglobin's oxygen-holding ability, with the intent to reduce red blood cell sickling. The drug later expanded to children as young as 4, but despite early promise, serious safety concerns emerged. Emerging risk signals and Oxbryta's withdrawal from the market. Post-approval and registry-based studies revealed higher rates of vaso-occlusive crises, VOCs, among users of Oxbryta compared to placebo or standard care. Additional complications included organ damage, kidney, liver, strokes, and in some cases fatalities. On September 25, 2024, a global voluntary recall of Oxbryta was announced by Pfizer following the safety concerns. Why Oxbryta lawsuits are being filed? After numerous reports of vaso-occlusive crises, VOCs, and multiple fatalities, people began filing Oxbryta lawsuits to seek compensation and justice. Plaintiffs allege that Pfizer and Global Blood Therapeutics, GBT, failed to conduct adequate testing of the drug's long-term safety in vulnerable populations. Claims include failure to warn doctors and patients of serious side effects and misleading marketing about Oxbryta's benefit/risk profile. Legal claims in these cases include design defect, failure to warn, negligence, breach of warranty, unjust enrichment. Who qualifies for the Oxbryta lawsuit? Anyone who took Oxbryta, voxelotor, for sickle cell disease and then experienced one or more of the following: increased frequency or severity of vaso-occlusive crises, VOCs, strokes, kidney failure or liver injury, death of a loved one. Eligibility varies depending on timing of use, the nature of complications, and when injury was discovered. What kind of compensation is sought in the Oxbryta lawsuit? In the Oxbryta lawsuit, plaintiffs seek compensation for past and future medical bills and treatment costs, lost income or loss of earning capacity if the injury impacted your ability to work, pain and suffering, emotional distress. In wrongful death cases related to Oxbryta, families can seek compensation for funeral costs, loss of companionship, and other damages. Steps to take if you believe you have a claim. If you believe you qualify for the Oxbryta lawsuit, it's important to follow some key steps to protect your legal rights. First, gather medical records, prescription history, documentation of complications, hospital stay records, and more. It's also important to keep a timeline of when you began taking Oxbryta, when symptoms began or worsened, and any diagnoses like stroke, organ failure, and more. Next, contact an experienced dangerous drug lawyer like the attorneys at TorHoerman Law for a free consultation and case review. How TorHoerman Law can help. TorHoerman Law is actively investigating the Oxbryta lawsuits, and we are ready to help individuals affected by Oxbryta-related complications. Our Oxbryta lawyers work on a contingency fee basis, so clients only pay for legal representation if we secure compensation on your behalf. If you or a loved one used Oxbryta and suffered serious complications, we're here to help you understand your rights and decide the best path forward.